I came, in fact, last year to give the talk, and it was interesting going over my slides and from last year, because so much has changed. Maybe not so much in terms of the environmental challenge that we see in Brussels for Ireland, but certainly in terms of Brexit, there's been an awful lot going on. I've been working for the last year, actually for the last 3 years, on defining what a level playing field might look like in the future, and also tracking the enforcement and implementation in the UK and what's being discussed there with the Environment Bill, and also the wranglings of their internal market market bill. So it's quite nice actually to get away from that for a while, and I'll be interested to hear what the other speakers have to say on that matter. But coming to Irish enforcement, I mean, the key sectors I would like to look at this year, maybe not, I haven't mentioned waste, but would not be so different from last year: water, nature, impact assessment, air quality, and governance. In fact, it's always quite useful to look at the overall statistics of open infringements that we have for member states. As you see here, hopefully, Ireland is somewhere in the middle in terms of numbers of infringements. Strangely enough, actually, the UK has a very high number. There's a very specific reason for that. We have a very technical directive that was transposed. So 36 for the UK isn't exactly a sign that we suddenly have a bigger problem with the UK. But sometimes these statistics are not always entirely representative, maybe of the severity of certain cases, or I mean, the numbers don't always show you the actual concerns we might have with a member state or former member state. If we look at the overall share of Irish infringements and the areas that they cover, we have quite a lot on water and nature and environmental impact assessment. Those are really the 3 key areas where we have open infringement concerns. If we look at the water sector, you'll probably be aware there was a judgment of the European Court against Ireland for failures to meet the obligations of the Urban Wastewater Treatment Directive. Basically, the 2 biggest agglomerations in Ireland around Dublin and also Cork are still largely not compliant with the directive. So wastewater collecting systems are in place, and increasingly in place also now in Cork, but the treatment plants still need upgrading, and that work is quite significant. It's also very expensive. I would say we're still tracking the implementation of the judgment. I would say it's a bit slow. I think more recently I've seen it has been recognised by the government, who have proposed to provide some more investments, hopefully to speed up compliance. But we have additional concerns also, which may end up in a new infringement, also about the management of individual and appropriate systems. That's the definition in the directive, which in probably more understandable language talks about septic tanks. We're looking at, not just in Ireland, but also other member states who rely quite heavily on these systems, to see that they have in place mechanisms to look at how they're run, how they're managed, and how they're inspected, and how breaches are enforced. So that is something we're currently also looking at for Ireland. Under the Water Framework Directive, we sent an additional reasoned opinion this year. It is actually an old case, as you'll see by the number. It was completely redrafted when Ireland adopted new legislation and was realigned. That's why we have an additional reasoned opinion. It effectively became a new case. The concerns we have there are mainly just about the lack of controls in Ireland over water abstraction. Draft regulations have been under discussion for a long time. And we have some concerns actually about the draft regulations that we've seen. But the aim would be to have in place a proper system and oversight and control, licensing, etc., for water abstraction in Ireland. I think in Ireland, the view has been for a long time that there is so much water and so much rain that this is maybe not necessary. But we're seeing with climate change and also with changing agricultural practices and people just using water more, that even in Ireland, where it probably has the highest availability of fresh water, there are certain areas where water scarcity actually is becoming a discussion point and an issue. So water abstraction controls are hopefully going to be in place in future. The other area we've been looking at is that there's a lack of control over hydromorphology, and that is where you control how not just river levels, but also I'd say the shape of rivers and canals is controlled, whether it's through dams and weirs, whether it's through flood protection mechanisms, and also through possibly rewilding and removing some of those barriers in rivers. So there are no proper controls, or we haven't found in legal terms controls over those systems that are in line with the Water Framework Directive. And that, I think, as I at the end will explain, we also have a number of areas where we will be looking at rewilding rivers, which is one of the aims of the biodiversity strategy, where hydromorphological controls and assessments are really essential if we know what we're doing and how we're going to control river health. The third infringement that we have, which we also had last year, which has moved to reasoned opinion, is the Drinking Water Directive on excessive levels of trihalomethanes. We're aware that Irish Water is working to improve water quality, but again, a little bit like for urban wastewater treatment, we feel it's a little bit too slow and more action is needed. If we look at the nature sector, we have still the open birds case, where basically the designation of sites, it was a significant increase was needed in the designation of bird sites, has been stuck for a while. We're still waiting for the last few sites to be designated for the corncrake and some other areas under discussion. The case that moved this year also to court, which was referred to court this year, and the papers are being prepared, is what we call the SAC case, the Special Areas of Conservation case. This is an action that we took across many member states, not just in relation to Ireland, but we've been looking at member states that either haven't fully legally designated all the sites that were proposed, to provide them with proper legal designation in national law. We're also looking at the lack of conservation objectives. So there's not much point just designating a site on paper. You need to set conservation objectives for the species and the habitats protected for each site, identify their vulnerability, identify the threats they're under, and identify targets for what you want to do to improve the health of those sites. The three, or particularly two of the key habitats and species that we're looking at are the freshwater pearl mussel, for which Ireland is particularly important as a host, and also blanket bogs. We're looking as those as specific examples in terms of the case that's been referred to court. That case obviously is still pending in terms of the paperwork that goes into the court, but the decision to refer has been taken, and we'll have to see how that plays out over the next year or two. The third case, which is still open and remains a problem, is the case we have on raised bogs and protection of blanket bogs. Significant progress has been made on raised bogs, but we find for blanket bogs there really is still a long way to go in terms of complying with the nature directives. If we look at the impact assessment sector, we still have late transposition of elements of the Environmental Impact Assessment Directive. There was a revised directive that came out a few years ago. We are at reasoned opinion with that, and we're still waiting for certain parts of the transposition to be completed. I think Ireland is now the last member state to complete transposition. We obviously have a more high-profile case, which is the Derry Bryan implementation. That is the judgment, a second judgment, which awarded fines for the failure to carry out a remedial environmental impact assessment for a wind farm in Derry Bryan. That case allocated a 5 million fine as a lump sum, but also still has running penalties of 15,000 a day. The environmental impact assessment process has now been formally started, but obviously the substitute consent process has been called into question by the judgment of the Supreme Court that was mentioned, and the process is going to have to await new legislation before the environmental impact assessment under the substitute consent process can proceed. That's something that we're looking at quite closely, although I have to confess I haven't read the 150-page judgment in full, but that's on my to-do list. We also have a case on peat extraction, the failure to have in place an effective environmental impact assessment process for peat extraction. Since the directive came into force, even the 85/337 directive, the lack of environmental impact assessments of any peat extraction operations in Ireland is something that is really of quite substantial concern to the Commission. So that case is currently at reasoned opinion. We also have concerns, although not currently an infringement, about afforestation and forestry management. I think that's something I would also come to later on. We have been trying to understand a little bit about how the process works now for a number of years. Irish afforestation is heavily supported by state aids and therefore also comes under a sort of scrutiny by the European Commission, and that scrutiny is still ongoing. There are a number of conditions that have been put in about future afforestation, and we've been having recently dialogues with the Irish authorities about how those conditions can be met and whether they've been met in the past and will be met in the future. I would say those are the main concerns we currently have on EIA. For air quality, compared to other member states, Ireland is, I mean, it's not a particularly urbanized country, so it's probably not so surprising that it's not one of the key member states that we have in our sights for breaches of the air quality directive. That said, this year, I think Dublin breached the European NO2 nitrogen dioxide limits for the first time in 2019. We found in urban areas, the cause of that tends to be excessive diesel engines that are not compliant with the highest level of Euro 6 standards, so that the nitrogen dioxide emitted is too high. We also have had quite a long-term concern about emissions of PM2.5, which are the really small particles, and PAH levels, particularly from residential burning of solid fuel, coal and peat. That is quite a concern that we have, because we found that the levels of these pollutants are coming from a very small percentage of residential housing. From the National Emissions Ceiling Directive, we have breaches and scheduled breaches foreseen for the future, particularly of ammonia, coming almost entirely from agricultural sources. And I think that is a particular concern, because we've seen those levels rising and going in the wrong direction. And that is something that Ireland will definitely have to tackle in the future. If we look at governance, I would say I was quite interested about the comments on a common law voice in the EU. I would tend to agree. I think that's something that we are going to need. I think Ireland is really going to have to work hard at presenting its legal system more, I wouldn't say maybe more aggressively, but to understand that for continental lawyers, it's quite difficult to understand some of the complexities of a common law legal system, particularly if they haven't had any exposure in terms of studies to that type of law. I worked for a long time on excessive cost case against the United Kingdom, and it was interesting to try to explain to common law lawyers, even internally within the Commission, how a common law system has its own checks and balances that may be different to a continental system. I would say that over the last few years, both in the United Kingdom and in Ireland, there have been significant improvements in access to environmental justice. But there are still issues in Ireland and in the UK, in fact, with high costs, delays. I was glad to hear actually that the delays are being reduced, but also about predictability in relation to the first issue of costs, but also more generally in terms of remedies that people can obtain if they do go through the whole court process. What has been very welcome has been the increased engagement, I think, of the national courts in Ireland with EU environmental law over the last year or two, we have seen some really, really good judgments actually, and very well argued judgments coming from the Irish courts, which has been extremely welcome. And we've seen many more cases also referred. I think previously, I think about a decade ago, there were almost no cases referred from Irish courts to the European Court on environmental law, or at all really. So it's been really interesting to see that there have been more referrals, and I think that's also helped engage the Irish courts with the European courts, which is a good thing. I would say we still have some concerns about the lack of clarity for future amendments that were announced. We were told, I think 2 years ago, that there would be an Aarhus consolidating bill coming forward. We didn't hear much more about that afterwards, but we then saw the 2019 housing bill, which was going in, I would probably say, the opposite direction in terms of remedying some of the concerns we had about access to justice. And more recently, we've been receiving a lot of concerns about some of the changes made to forestry appeals that we've been looking at and have also raised with the Irish authorities. I think I should also mention at the EU level, this is not specific to Ireland, we have proposed an Aarhus regulation. Some of you may have followed this issue. There was a complaint about the European Commission and access to justice through the EU processes. So if that's of interest, there's a new communication has come out explaining a little bit about how the European Commission sees improving access to justice in environmental matters at the EU level. I would say those are probably the main areas of concern that we have with Ireland in terms of legal infringements and cases that are open. But the challenge now would be not just looking at those individual legal cases, but looking at how the existing legal structure is going to react to some of the new policies that have been coming out very, very rapidly from the EU level under the new Green Deal. We had some discussions about that, I think, last time I came to Cork, but we now have the biodiversity strategy, which is focusing not only on the protected areas of the SPAs and the SACs, but also extending those nationally to encompass high nature value land and other similar lands, so that we have many more areas that are protected. The idea of freeing up river flows, of forestry, and also linkages to biodiversity friendly farming. That is, I think, something particularly for Ireland that will be the big challenge of the future. And the biodiversity strategy links in very closely to the farm to fork strategy, with ambitions in particular for increased organic farming and reducing pesticide and fertilizer use. And there's a new principle which you may not have heard of to such an extent previously, which would be the do no significant harm principle. This is something that was also new to me, but the discussions we're having now at the EU level is to find ways of integrating, not just to have environmental policy, and this has always been an aim for a long time, not just to have environmental policy as a standalone policy, but also to integrate it more into the areas that are dealt with by other Directorate Generals, but also nationally by the other ministries. And that, I think, having looked at this over the last year, is the big challenge. And for DG Environment, we're looking at this in particular, not so much in enforcement terms, but in terms of future policy and investments, and looking at how member states are investing and using EU monies also for investment, that they abide by this relatively new principle, I suppose, of the do no significant harm principle, that when you propose investments in whether it's roads or rail or energy infrastructure and other infrastructure, that you find ways of showing that this will not do significant harm to the environment. And how that is played out in future will be quite significant. I would be interested to see whether it becomes something that seeps into the legal principles. For now, it's a principle that's mainly being discussed at the level of the MFF, which is the sort of the future funding and budget spending level. But it is, from a legal point of view, quite an interesting principle to see and to see how it becomes operational. If you are interested in seeing how some of these policies are connected, not only to funding, but also in terms of other areas dealt with by other parts of the DG, I have put the link in to the European Commission Dublin office website, which basically shows some of the links to the key areas on environment, or that link into environment, also from climate change and also from agriculture. For Ireland specifically, I would say that the main challenges are, or what has been really positive in the last year, particularly with the new government, has been the decision to move away from peat for energy, finally. The decision to move towards a significant increase in renewables. Also the ambitions to retrofit so many households for energy efficiency and heat pumps, electric vehicle targets and targets for improving cycling. I think these have been really very positive elements of the new government's programme. But the area for future, and I think that was also echoed in the introduction, is really for Ireland is how to integrate its agricultural and forestry ambitions with water and biodiversity protection. There, I think we really need to do a lot more work, both at the EU level, but also through enforcement, but also through dialogue with Ireland.